5 seconds. Still later, the same very question cropped up before the Supreme Court in special leave against the aforesaid full bench decision of the Punjab and Haryana High Court. Bikram Das versus Financial Commissioner Mothers, the Supreme Court held that Rule 3 of Chapter 2C Punjab and Haryana High Court rules and orders was directed and not mandatory. That being so, substantial compliance therewith was enough to meet its requirements, since one complete set of 3 documents specified in Rule 3 was filed along with the memorandum within the prescribed period of 30 days. There was substantial compliance with the rule, and therefore it was erroneous to treat the appeal as being barred by limitation. So, the failure to file the 2 additional sets of document was a mere irregularity which the High Court, in exercise of its discretion, could condone by granting further time for formal compliance with the rule. On facts, the Supreme Court found that there was sufficient ground for condensation of delay. The following further observations made by the Supreme Court in this context are very pertinent to note. Section 5 of the Limitation Act is a hard task master, and judicial interpretation has encased it within a narrow compass. A large measure of case law has grown around Section 5, its highlights being that one ought not easily to take away a right which has accrued to a party by lapse of time, and that therefore a litigant who is not vigilant about his rights must explain every day's delay. These and similar considerations which influence the decision of Section 5 applications take of place in cases where the appeal itself is preferred within the period of limitation, but there is an irregularity in presenting it. Thus, in the instant case, there was no occasion to invoke the provisions of Section 5 Limitation Act or of Rule 4, Chapter 1 of the High Court rules. If the division bench were aware that Rule 3 of Chapter 2C is directory, it would have treated the appeal as having been filed within the period of limitation, rendering it inapposite to consider whether the delay caused in filing the appeal could be condoned. As a learned judge of Punjab and Haryana High Court said in Guru Bachan Singh versus Mastan Singh etc. 1984 1 RCJ 619. These rules have been made by the High Court to further the ends of justice. A party cannot be given undue latitude in complying with the orders of the registry to remove the defects pointed out in appeal. the appellant cannot be permitted to move at leisure. If great latitude is given to the litigants, then they might not only take months but years for complying with the orders.